And that's defendant's motion to preclude accuser's attorney from addressing the court beyond the limits of Section 54, Connecticut General Statutes 54-91C. Let's do that first. Counsel.
Yes, Your Honor. So, Your Honor, I did file this motion earlier this week. I think the law is clear. Connecticut Constitution provides for what's called the Victims' Rights Amendment, which was then codified in Connecticut General Statutes 5491C. In reviewing those, Your Honor, it is clear that the legislature did not intend to elevate the status of an accuser to that of a party, and that was made clear subsequently in the State v. Galt matter. But even more so, Your Honor, the statute and the constitutional amendment are clear as to what rights accusers have in the process. And with respect to being heard in court, both the constitutional amendment and the statute are clear that they have a right to be heard at the time of plea and at the time of sentencing, not at other stages of the proceedings. And I think it's relevant that the legislature decided to make it at the time of plea and at the time of sentencing. Clearly, at the time of sentencing, the issue of guilt has been determined. If someone is entering a plea, usually they're being heard at the time of a guilty plea. Someone has agreed to enter a plea. We are at a much different stage in the proceedings. We are early on in the proceedings. There is still a presumption of innocence that my client maintains, and her rights need to be protected. The accuser does not, I believe, pursuant to the constitutional amendment, the statute, and the case law, have the right to address the court at other stages of the proceeding. And the legislature was clear to do that because I believe the legislature was clearly concerned about infringing on the rights of the accused. And that is the focus here, the rights of the accused and the safeguards against the state. Your Honor, I filed this motion. I went through the constitutional amendment. I went through the Connecticut General Statutes. We went through the case law as well. I think the argument that is laid out is very clear. But Your Honor, I also would caution the court because one, I don't think the law permits it. Now, in practice, accusers have been permitted to address courts at different stages, but I think that creates a dangerous precedent and a slippery slope. In this case, the accuser has counsel. But if we permit the accuser's counsel or the accuser to address court at any stage of the game or at any proceeding of the game, we are creating a right that the legislature did not envision. And when you create that right to be heard, you also, with that, I think, requires notice. We would be setting a precedent that in every case in this court, an accuser has the right to come in and be heard at various stages of the game. It would cause an unbelievable backlog, unbelievably interfere with the orderly process of the court, and create a right that simply does not exist, Your Honor. We cannot have accusers coming in at various stages, requiring notice, and requiring an opportunity to be heard at any stage in the criminal proceeding. The legislature was clear at the time of plea and at the time of sentencing. Respectfully, Your Honor, I would ask the court grant this motion and not extend rights where they are not permitted by statute or the Constitution, Your Honor.
So briefly, Your Honor, I think the Constitution and the statutes try to strike a balance between the right of the accused and the victim's rights. Our state constitution specifically states the right to be reasonably protected from the accused and throughout the criminal justice process is a right afforded victims. I'm not advocating that there's a right to be heard or given notice for every court appearance, but I think when the court is addressing conditions of release that affect the safety and well-being of the victim, that is information that if the victim wants to provide, the court should be able to hear from that victim or the victim's attorney and take that information into account in fashioning any decision from this court. It doesn't give them a party status to the case. And I've not heard one thing that prohibits the victim's attorney or the victim from speaking at a hearing such as this. So based on all that, I would ask that the victim's attorney be given an opportunity to be heard. I mean, who can best speak to the protection of the victim and the safety of the victim and what the victim's feeling, but the victim himself or a representative of the victim?
All right, I'm going to make a ruling before Mr. Riccio wants to be heard after that. He can, but this is the court's ruling on this particular matter. I have had the opportunity to read through defense motion, case law that's been supplied by the defendant, and I would note that obviously all of the court system supports the Victims' Rights Amendment, which requires certain things. It allows an individual that's been identified as a victim in a matter the right to attend the court proceedings, the right to object or support a plea agreement, the right to make the statement to the court prior to the acceptance of the court of the plea of guilty or nolo contendere, the right to make a statement to the court at sentencing. Basically, it provides the victim a right to be heard within the process so that both the state and the court can take into consideration their feelings. We have victims' rights advocates, we have the Office of Victim Services, we have Domestic Rights Victim Services. All of those individuals provide information to the state of Connecticut, and then the state of Connecticut forwards that information to us. And I think that's what the court is going to hold the complainant's attorney to in this particular case. I'm going to emphasize to Mr. Riccio, I'm not sure the entire initials that the gentleman is using right now, the protected party, but to Mr. Riccio, the protected party is his client. To the state of Connecticut, he is a witness, and a crucial witness in the state's prosecution against an individual. And so as such, he has a right, or he has the right to have his lawyer attend the proceedings, but he doesn't have the right to argue motions within the court system. As Galt, State versus Galt, G-A-U-L-T, 304 Connecticut, 330, 2012 decision states it is a basic tenet of the criminal justice system that prosecutions are undertaken and punishments are sought by the state on behalf of the citizens of the state and not on behalf of a particular victim or complaining witness. A criminal prosecution is a public matter and not a contest between the defendant and his victims or his relatives. It is axiomatic, therefore, that the parties to a criminal action are the state in whose sovereign name it is prosecuted and the person accused. So I want that clear, that there are only two parties, and while obviously the protected party's attorney may advise the court as to what his position is, I will not allow any argument regarding any of the motions that are pending. It is a criminal action that's been brought by the state of Connecticut. You can, I'm well aware this office has a thorough and complete connection with the victim services and have always provided this court with accurate information regarding what the victim's position is on this matter. So with that, I am going to grant defendant's motion as to limit it to the the protected party's attorney to what his feelings are regarding the disposition, and that's it. I'm not going to listen to argument regarding any of the motions that have been filed by the state of Connecticut. You appear to have a question, Mr.
No, I just want to make a statement. It was not the state's intention to advocate that the defense attorney, the victim's attorney, be allowed to advocate or argue motions. That was not the point of the state's comments.
All right. So having said that, and if I bring the motion has been read, as I indicated, I know Mr. Riccio has addressed the court before. I don't have wishes to address the court again. Again, not listening to argument on motions or bonds or the complaining witnesses' position. There's been some change. You're welcome to report it to the court in terms of how the witness feels about prosecution in this matter. I've been advised advised by both parties they're closing up on discovery. Hopefully the court's rulings today will put the finishing touches, if you will, on the exchanges. And the state has indicated to me that it anticipates that he will be able to make an offer on the next court date. Prior to that date, he will obviously, Mr. Thurkelson or Attorney Platt will be in touch with Mr. Riccio and advise protected party what the offer from the state might be. Other than that, did you want to be heard further, Mr. Riccio?
I just wanted to, I respect and understand Your Honor's ruling, but I just wanted to put a couple things on the record, if I might, on behalf of the victim. I'm here with Attorney Infante. I think that the right to be protected against the accused is a enumerated constitutional right, and it's inconceivable to me, frankly, why we would, as victim's attorney or complainant's attorney, we would not have a right to be heard. By addressing the court, it's not granting us party status in any way. It's a very limited participation, and I'm well aware of the decisions cited in this brief that I can't attend a pretrial, I can't take an appeal, but that's not what, we're certainly not asking to do that. As you well know, I'm a criminal defense lawyer. I'm well aware of what my limitations are. And as argued by the defense, again, allowing us to address the court on this issue, referring to the conditions of release, which directly relate to my client's safety, that's what's concerned to us. We're not trying to influence the outcome of the case. I'll make one final point, which I think is important. This is a domestic violence case. If I could, okay?
No, I'm just asking that to tap because the microphone's on.
Oh, I'm sorry. Okay, I'm sorry. I'm getting too enthusiastic.
I was trying to do it with my hands, so go ahead.
Sorry. This is a domestic violence case. These parties were related by marriage. They were part of, and I tortured the English language to call this a household as opposed to a torture chamber. But it qualifies as a domestic violence case. Obviously, the domestic relations office would not get involved in something like this. But if they did, okay, there would be a domestic violence person here who would have talked to us, talked to the victim, got his ideas about the situation, and conveyed that information to the court, right? The domestic violence supervisor. Addition edit, for example, an arraignment. Domestic victims, their lawyers frequently, as Your Honor is well aware, frequently address the court during the course of cases involving domestic violence. And this is a domestic violence case. So I would just respectfully say that, and what I'm trying to say is that if just the fact that family relations doesn't want to get involved and shouldn't get involved, I get that, right? That eliminates all of the vehicle to communicate to the court our concerns about modifying the conditions of release. And respectfully, I just don't think that's correct.
Well, I'm not certain that's what the defense was arguing. Under no circumstances, not getting that impression that the state has ever precluded you from asking to represent victims' feelings regarding the conditions of release. I think the state's attorney's office here has been an ardent advocate for certain restrictions on, and regardless of whether it was domestic violence or not, they've always, the state attorney was always able to present to the court their concerns regarding conditions of release and why they should be restricted or otherwise. It's not limited to a family violence case.
I totally agree with that. You've done a fine job in this particular matter. But again, because it is technically a family case, I think we should respectfully, and we've ruled, respectfully have the right to individually address the court regarding our safety concerns regarding our client. And obviously, this is a very, very serious situation. So, thank you.
Thank you. Okay, sorry. So we have the state request for an order of condition release of medical records of victim. There's also defendant reply memorandum and state's memorandum in support of order of condition release. State's attorney's office. Your motion. And as I understand it, so you raised 6 points. Items 1 through, well, we have 2 left. Items 1 through 5 on the first page of your motion, I think are standard conditions that are placed on any medical records that are released to the defense counsel. I don't think that either side is opposing that, and I would grant counsel's motion. On the second page, you also start with number 5, and that's, on the second page is the defendant shall not be given any medical records or copies of medical records with the victim's alias or location, and shall not be told or have access to the victim's alias or location. I think that's the one that both parties are in disagreement on, so I'll hear counsel on that.
So we've submitted a written brief, which I know the court has read, and we've discussed in chambers, that clearly spells out the court's authority to put the requested protective order in place. The state is asking for that 6th item, that the defendant not be given access to the alias or the location of the domestic violence victim at this time. The defendant and defense counsel already know the true identity of the victim. That's not a secret. He's under an alias at a location that is not disclosed for his mental health and his physical safety. His current medical treatment will go on for years. The defense will have all the medical records for the time of the trial. It has no bearing whatsoever, his alias or his current location, that the defendant be made aware of that. You know, the principle behind giving addresses and locations to defense counsel by the state is out of fairness. And that fairness is so the defense can have an opportunity to interview witnesses and prepare their defense. In this case, the witness in this matter and the domestic violence victim is represented by Attorney Riccio. So for any contact with the witness in this matter, Attorney Colordis and his firm would have to go through Attorney Riccio. So that makes the address of no importance whatsoever, because they have to go through Attorney Riccio to contact him. They can't just show up someplace and talk to him. The victim is terrified of this defendant. The allegations is he was literally almost dead when he made his escape from that room he'd been locked in for 20 years. He's at a care using alias for his, at a medical facility for his care and his safety. This is no different than a domestic violence victim being at a safe haven home. He certainly wouldn't disclose the address of a safe haven home to a domestic violence abuser, and that's the case in the state's position that this is. Additionally, this alias and this location being not disclosed is for the safety of the victim from the general public. The state would argue he has certainly a right to be left alone while he heals. As the court is well aware, this case has attracted nationwide media attention and continues to do so. If this address is somehow leaked, it'll be a media frenzy where this young man is trying to recuperate. The only thing a disclosure the defendant does is put the victim's safety at risk. The risk of greater harm to the victim, there's no prejudice to the defendant. I have no doubt Attorney Colordis and his associate would not disclose the address to the public. I do have grave concerns giving that information to the defendant. I also doubt there would be any sufficient remedy this court could give if that information was ever leaked by the defendant.
Thank you, Your Honor. Your Honor, the problem we have with the state's request is, in every case, names and addresses of witnesses are provided. That is standard. They're asking for something different in this case. They're asking for something exceptional in this case. They're asking us not to share with my own client information about the case. Yes, it's the name and the address. The name, I think, has more relevance than the address does. But that aside, for the state to ask the court to make an exception in this case, I believe there must be some type of showing by the state that this is necessary. Now, they're saying for his safety. Those are conclusory statements. There's no issues with respect to his safety if I share with my client his name or address. There are no safety issues. Just because they say there's a safety issue doesn't make it so. And I understand the complainant may not want my client to know his new name. He may feel that he doesn't want her to know his new name. Maybe that he doesn't want her to have that power over him, or whatever woke expression that there is now. But the reality is that there's no basis in the law to withhold this information absent any real concerns. And the state has not provided any evidence of any real safety concerns other than, I think this really comes down to his own feelings. He may feel better if she doesn't know this. But there is no safety issue posed to him by her knowing this. The issues that are raised on our end are significant and are based in the law rather than feelings. One, it interferes with my client's right to confrontation and also interferes with my ability to prepare for the case. The name that someone has chosen, an identity that someone has assumed, whether it's given to him at the hospital or whether he himself chooses it, if he sticks with it, it seems, I would argue, has relevance. What is the name? Why was that name selected? What relevance does that name have to him? My client may know some of those answers, knowing him better than I do. And if I can't share with her and ask her, hey, does this name have any meaning? Does this mean anything to you? Has he ever mentioned it before? Those are basic questions that we would be able to discuss with our client, and this would be tying my hands. Additionally, Your Honor, it also interferes with my ability to adequately investigate the case. Part of the reason why you know someone's name and address is so that you can do proper investigation. So your private investigator can look into it. There could be social media posts, there could be membership somewhere, association somewhere. If you don't know someone's name, how are you going to look into those things? I have an ethical duty to investigate this case and adequately prepare for this case. Such a restriction would tie my hands. Your Honor, also, the state cites two Connecticut General Statutes 5464A. That statute provides for the disclosure to the defendant. The statutes cited by the state in their memorandum provide for disclosure to the defendant. They protect against public disclosure, and we understand there's concerns with respect to the general public. But that should not tie our hands. We have no problem not disclosing the name. We regularly do not, we get information in discovery all the time that we can't share or use for any purposes other than the preparation of the case. This situation would be no different, Your Honor. And I think absent some type of actual showing, rather than just a statement of how someone might feel or a generalized safety concern, there's nothing in the record to support any safety concerns. My client has abided by the protective order for the last almost 8 months now. There have been 0 issues. There's no evidence to support this claim of safety concerns, Your Honor. Respectfully, I would ask the court, order the state to disclose the records without any further restrictions.
Right. So I have had the opportunity to read through, as I indicated previously, the state's request and the supporting memorandum on each. In some, the state seeks to keep the protected party's alias, chosen alias as well as location from the defendant. I was not aware, to be quite frank, that the defense had it, and I'm going to assume that the state's application or request here is just as to the defendant. I did have the opportunity also to read through State versus Peeler, which is cited to in the state's brief. The court does not feel that Peeler is applicable to this factual situation. Certainly, State versus Peeler showed an entirely different defendant as well as an entirely different set of factual circumstances. You had in Peeler a gang leader with a history of violence and specific threats that were made against the witnesses. In the present case, we have an individual that appears before the court with no criminal history and with a protective order in place, and it's been several months and there's been no issues or allegations. She's been monitored through through bail commissioner, And there's no indication that there's any type of violation regarding that. There are a number of statutes that deal with information that can be provided to defense and in turn then to the defendant. Any number of statutes, 46B-30, let me back up a little bit, in terms of the allegations, there's no question in the court's mind based on the warrant affidavit and the factual allegations that this particular case meets the definition of a family violence crime as defined in 46B-38A paren C. The factual allegations are clearly there. And there are a number of statutes that protect, not just family relations matters, but protect witnesses. Most specifically 54-86D. There's certain statutes that protect shelters, 46B-38K, that protect from harassment of witnesses, 54-82Q. Now, obviously, the confidential nature of this particular factual allegations in this case allow for the confidential requirements of 54-86D to apply. But confidential does not mean not given to the defense. The law that requires confidentiality requires a shield from release to the public. It does not require a limitation of release to the defense or in turn to the defendant. The defendant has a right to defend the case, the charges against her, and the allegations against her, and certainly knowing that the basic name and location is necessary for just a simple basic investigation. You know, I'm often concerned by the argument that why does the defendant need this? You know, that's because we have a constitution here, both in the state of Connecticut and the U.S. Constitution. And our Constitution requires that certain citizens have basic rights, and under those constitutions, if those rights are going to be taken away or they're going to be imposed upon, then the state needs to justify why. And in this case, my job is to simply apply the laws that are existing, the current laws. It's not my job to create law. There's no statute, there's no case law that prevents the release of the name to the defense or to the defendant in turn. For trial purposes only, each statute that requires confidentiality of these names, each one refers to the fact that the defendant has a constitutional right to basic information in order to present a defense and confront his or her accusers. There's, as I indicated, there's no state or case law that prevents this release. There's no facts or evidence offered by the state to suggest the need to deviate from these statutory protections. I understand that the protected party is frightened to death, and that's quite frankly, that's a consideration we take into that's something we take into consideration every day with every case that appears before this court. That's why we set bonds. We consider the safety of the complainant. That is not the basis for going outside what the law requires in terms of presenting evidence in terms of the defense. So I will not grant the state's request as to the page 2, paragraph 5, and specifically as to the defendant shall not be given any medical records or copies of medical records. I want to be clear, counsel, you can explain this to your client. The court's order allowing the release of that information to you and then in turn to your defendant, it is only for trial purposes. And this is what I'm referring to as a strict liability type of release. I don't care how or whether, if this information gets out in the media, to the press, to in any way, shape, or form, I guarantee you the police will be able to locate how that happened, and I want that individual brought before the court on a summary contempt charge. The information is to be used for trial purposes only. And specifically, Ms. Sullivan, I am telling you right now, you can speak to your lawyers about information they give you. You cannot speak to anyone else. I don't care how close the confidant is. You cannot, other than to your attorneys or someone who's hired by your attorneys to present this defense in this case, you cannot release under any circumstances. Again, I guarantee you, if there's a violation of this court's order, the violation of the court order, you would be facing summary contempt charges. You understand me, miss? Yes. All right. So with that, that's the court's order. Now, finally, we have defendant's motion to be heard. Modify the conditions of release. If not, again, I'll allow counsel.
Your Honor, I'll be brief. The motion spells it out. This case initiated on March 12th. My client, Ms. Sullivan, has been free on a $300,000 bond, which was posted. She's also been monitored for the last 7.5 months. We're approaching about 2 weeks shy of the 8-month mark. There have been 0 issues with respect to her compliance. She's done everything that's been asked of her. There have been a number of issues with respect to the device itself, malfunctioning numerous times. Those are included in the motion. Since the writing of the motion, there have been additional issues. The GPS has been swapped out as recently as October 17th due to issues with it. Your Honor, respectfully, given the time that this case has been pending, my client's appearance in court, and the lack of any problems or any issues whatsoever, I'd ask that the court remove the GPS at this time. I think the $300,000 bond is more than sufficient to guarantee her presence. I'd ask the court grant the motion.
State would object to the granting of the motion. State would ask the GPS monitoring remain. This defendant is 57 years old, facing 45 years of incarceration, is currently charged. For all intents and purposes, she's facing the rest of her life in jail. It's a pretty good reason not to come to court. It's interesting to note that in the defendant's motion to modify the conditions of release, one of the things the defendant relies upon is that she does not know, the defendant does not know the location of the domestic violence victim in this matter. She will now know that. That's an additional reason to keep that monitoring on. Domestic violence cases in this court for far less serious charges with far less liability are routinely granted GPS monitoring. This domestic violence victim in this case is terrified of this defendant. The allegations are he was locked in a room for 20 years and was on the verge of death when he made his escape. He certainly has a right to be terrified of her. I disagree it's too great a restriction. The court certainly, I mean this with all due respect, has the authority and can grant any modification of the condition of release. But these exact conditions have gone up to the appellate court, and they found that it was appropriate in this matter. I would point out today's probationary report. I do not agree that it's too restrictive. I would actually argue it's the least restrictive things. This is the words of the defendant. She spends her days mostly going shopping with her daughter and parks in the area. And now the claim is that the GPS monitoring is too intrusive. I think to the contrary, that stands for the argument and the proposition that it is an appropriate condition of release.
All right, just in all fairness, the motion to modify the conditions of release was filed on August 29th. Your motion to keep the name was filed on September 24th. But again, I've listened to both parties. Again, I don't see a change in circumstances that would require the court to reconsider the conditions of her release. What's particularly concerning, I think, to the court today and has been in the past is that the lack of permanent location for her. I know that there's some indication that she may be returning to the original residence. I don't know that that's happened yet. And I think that was the judge that set these conditions, that was his major concern. So at this point in time, the court is not going to grant the motion to modify the conditions of the release. I will indicate if the problems with the monitoring equipment continue, then we can certainly address that with the Bell Commission. Right now, the motion is denied. It is simply too soon in the case. At some point in time in the future, and if the defendant develops a solid, steady residence in some permanent location, then obviously the court will reconsider the motion, but not at this time. So those are all pending motions?
I believe so.
I believe that's everything, Your Honor.
And I'll just indicate for the record, I'll leave it as part of the file, there is a compliant Bill Commissioner report.
Thank you, Your Honor.
We did speak, I know that there were two suggestions the court made to both attorneys. One, to provide a list, to go through all the discovery you have, if there is some sort of suggestion for what's missing, or what you believe should be exchanged. Again, I want you to come to court next day with that specific list. I believe we chose December 12th?
19th, Your Honor.
December 19th. So we'll have that. Counsel, if you hire an expert, make sure that report is going to be done and made available. It won't be done by the 19th, but make sure that you provide the state with access to that as well.
Of course, Your Honor.
So on December 19th, I would anticipate that we are at or near the end of the discovery stage. The state may even be able to have proposed an offer in this particular matter. Please run it by Mr. Riccio, and he can run it by his client before the next court date.
That's right.
Okay? December 19th.
Thank you, Your Honor.
Thank you, Your Honor. Thanks, Steve. All rise. Court now stands adjourned.